injunction against its placement on the ballot. Your Honor, if you have, happy to answer any other questions that the court may have.
No, I guess the only thought I have when I hear that argument is that we had 27,000 people who signed this. And, that's a lot of people who signed it. But I guess your point is, if it violates state law, then that's the law.
Your Honor, it's the law, and it is simply compounding the problem to have the voters of Davidson County vote on something that is void ab initio. Then it will not just have gone through a—
You say void ab initio, you mean what? From—
It's defective. It is defective now. It can—
I'm sorry, it's defective what?
It is so defective it will never take effect, Your Honor, because it fails to comply with form requirements, subject matter requirements. For all those reasons, I don't think it does the voters any favor by having them vote on something that a court will hold illegal immediately after the election.
I had discussed with Mr. Roberts whether there are circumstances in which the Election Commission or the court, before the measure is placed on the ballot, can say, no, this can't go before the voters. And so what you've argued to the court is this is a situation where the court should intervene. Okay.
Exactly, Your Honor. This is what City of Memphis says, that in these limited circumstances, a pre-election review is not only appropriate, but should be undertaken. And the point of that pre-election review is to keep from going forward with an election on something that should not be on the ballot.
All right, Mr. Cooper, is there anything else that you want to say on behalf of the Metropolitan Government? This will be your last opportunity to speak. In the case, do you need to take a break and talk with Ms. Fussell, just a 5-minute break so you all can confer, or, well.
Your Honor, we don't have anything else. I guess just to follow up, if I could, on the discussion that you had with Dean Koch regarding potentially sending this back to the Election Commission.
Yes.
If you look at the transcript of the meeting by the Election Commission, they engaged in extensive deliberation and reached I think, reasoned conclusion that given all the concerns about legality and form, that they could not make an informed judgment about whether to put this on the ballot or not. That is, I think, an appropriate position for them to take, and it's an avenue that is open to them under the Cummings decision to, in such a situation, go seek the guidance of a court. So we don't think that it's necessary for that to go back to them for some sort of decision before this court can act. The court may make a determination about the validity of the amendment and then send it back to them, but we think it is properly framed now for the court to reach the merits of this matter.
All right. Thank you so much, Mr. Cooper. That concludes the closing argument by the Metropolitan Government. This time, Mr. Roberts, I will take up the reply of the plaintiffs.
Thank you, Your Honor. And I promise to be brief because I want this to be my last opportunity to speak as well. I would like to start by saying I apologize if there was any confusion in the beginning of some of the questions you asked me. You asked me some specific questions about, and you used the phrase illegal. And
I used unlawful and illegal, mostly using unlawful. So,
I struggled with that, Your Honor. I apologize because I wanted to make sure that I wasn't conceding something beyond facially unconstitutional when you said unlawful. Because I do see that as two separate things, and I didn't want to get sort of trapped.
And I understood that. I was trying to think of a word that would cover both form, procedure, the subject matter subset under form, and facially unconstitutional. And the word I came up with, my first one was illegal, and then I hit unlawful, but I can understand your confusion. So that was my definition of that. Okay. But I think we finally got it straightened out anyway. Okay.
I just didn't want you to think I was being evasive or anything.
No, I understood, because it's hard to come up with a word. I've thought of that myself. Okay.
The second chart, and I want to start a little bit in reverse. If I could share the screen just very quickly. This is the only example that I'm going to show.
Okay.
Hold on up. Not pulling.
Did you get the shared screen? Yes. Okay. Very good. All right.
And I was a little troubled by something that Mr. Cooper said, and about advocacy, about being able to promote your views. And I would like the court to see this was the referendum in 2006, which is part of the charter, which was passed by the people of Davidson County, much like this provision in the tax is. And it says the willingness of and ability of citizens to bear the burden of a tax increase should always be considered. And I would submit that that is no different than the petition itself saying, our petition, saying the same sort of language, that clearly Metro has allowed some sort of, I don't even call it advocacy, but it is, I guess. You're allowed to put things in a statute that aren't exactly all technical in nature. And for the metropolitan government to allow this and not allow it in other circumstances is pretty much a per se violation of the First Amendment. That is a content-based restriction. And I appreciate Mr. Cooper's admission of that. If this were ever to be an issue, that will be exhibit one in why the metropolitan government is trying to stop this. And that's, I would submit, Your Honor, that the citizens, whether it's the Community Oversight Board or some other group, is put in there what they want. And then if Metro makes a decision to exclude a ballot initiative, a lawfully gathered signatures and certified signatures based on its content, I would submit that they will absolutely be sued under the First Amendment in the future. And I would be happy to be a part of that. That is that they've allowed.
How does that position, though, how is that consistent with the City of Memphis case, which says that there can be violations in terms of form? And we get back to this, and then we've got the Hazelwood case that they refer to. So there can be violations of form. And when I look at this referendum, it does have some what I call marketing language to it. It's got the checks, it's got the bolding, and then it uses marketing type terms like giveaways and,
I concede that this was designed to get people to read it, to sign it, and to vote for it. And so if that's termed as marketing, then I would say that that's probably accurate. I would also
if we put marketing on the ballot, there's a difference in giving someone a piece of promotional partisan literature and saying, I want you to support this. But in terms of the purity of the ballot and keeping partisan matters off, yes, I see that's a statement, but when you contrast that petition here, where again, we're using bolding in terms like giveaways, when I hear the word giveaways, it really does make me think of marketing. That's what I usually see when somebody's offering me a prize or, if they want me to sign up for something.
Well, we're not giving it away to the voter. We're actually keeping it for the voter. But
no, but you use that term, which is very much a marketing term.
Absolutely. And I would submit that putting a preamble or as part of a thing that says the willingness and ability of the citizens to bear the burden is also marketing. I'm certain that was put in. I was not.
There are differences in degree, for sure. I mean, the law all the time is making differences in degree, but I understand your position. Anything else on that?
Just a few things, Your Honor. One of the things that Dean Cope said, actually, one of the main things that he talked about was that we're going back to this just a little bit about whether the December date is conditional or not. And
Yes.
one of the statements he made to you was that the only condition that the court would rule that the petition was valid, that was the only thing that would trigger the actual election on that day. And I would submit, Your Honor, that is just not true. That is inconsistent with what was said at that meeting on September 25th. It's inconsistent with any evidence that's been presented that this court's order by itself would cause anything to happen as it relates to Jeff Roberts, and his duties at the Election Commission. That is just just inaccurate. That again, and that almost in some ways highlights the problem with the actions of the Election Commission on that day. Dean Koch also followed that or suggested that we all knew that there would be litigation, that from the second this was done, there would be litigation. I don't think that is an untrue statement. Had the ballot initiative been placed on the ballot, certainly we wouldn't have filed suit. Had the ballot initiative been placed on the ballot and the commission had followed Mr. Delaney's suggestion that one provision about the bonds be excised, we may or may not have litigated. Our decision to litigate was based entirely on the failure of the Election Commission to act, either act pursuant to its ministerial duties to place it on the ballot, or act pursuant to its own vote on September 25th to file a case. They may have voted to hire counsel and to seek a declaratory action, but they hadn't done it. The litigation coming from our side was entirely caused by a failure to act on the other side. And I'll leave it at that. That's one of the issues, switching a little bit to Metro, and I think this is very critical, Your Honor, that this is what we were afraid of from the beginning, is that we would come in here and have an argument about this, and that Metro would bring forth a parade of horribles. They would tell us all the terrible things that were going to happen. They would tell us about, I think they used the phrase, the domino effect. Well, Your Honor, in some ways, we concede that there will be a domino effect. But what we assert is that the domino effect would be for the good, not for the bad. Metro, not surprisingly, the government thinks anytime you take tax dollars away from it or restrict its power, it thinks that's terrible. I get that. I understand that. But the people don't see it that way. The domino effect we see from rolling back the tax increase is to cause Metro to make hard decisions, which is their job, to bring our fiscal state back in order, and to take the burden of the mismanagement of this city off the backs of the taxpayers. We see the domino effect is helping the poor. We see the domino effect as the elderly and the affordable housing. And we see a lot of good domino effects out of this. And let's just simple our position. Obviously, Metro sees bad domino effects. We see good domino effects. The fact that they're effects.
Does it change the argument if you characterize Metro sees unlawful effects instead of bad?
That's certainly, Your Honor. That is, I was mainly speaking to the results of the ballot initiative if passed. I'm not referring to lawful or unlawful, but let's assume.
Well, but that's really what's before the court. I don't make policy decisions on, what's good and what's bad. I have to follow the law. And what they've said is that the referendum on its face is defective. It's invalid. It violates the law. And that's why they're asking me to strike it down. And whether it's good, bad, whatever on policy is not the province of this court. So I guess I'm just questioning the relevancy of the argument.
Well, no, that's exactly the argument I was making, that I felt like the Metro was trying to bring policy into this because of the effect it would have on their policy. Absolutely.
No, actually, it wasn't policy. What they did is they explained, and let me just, we had a request here for injunctive relief, and we know that you have to show that there's going to be an impact from it. And that was why it came in. The court did not allow that testimony as a parade of horribles. It was because of the impact that Metro has to show for its injunctive relief. And then also some of its claims about it being unlawful, like violating the state statutes on the bonding or the contract, retroactive contracts, taking, that was why the court let it in, not in any way. I want to be clear because we don't deal with policy here. It's just, is it lawful or not?
And that was my only concern. And lastly, Your Honor, Mr. Cooper made a statement. He said that there was no dispute that the Burnell case supports subject matter analysis. I wrote that down exactly, put it in quotes. I don't dispute that in West Virginia. I have no doubt that in West Virginia, the Burnell case supports that. The question is when the Supreme Court referenced that site, as we argued before, did it bring Burnell's reasoning on all issues, specifically subject matter issues, to Tennessee? The validity of Burnell is in West Virginia is irrelevant to this, or should be irrelevant to this court's analysis.
Well, as everyone has pointed out, we don't have Tennessee law on this situation because it's a metro charter provision that's pretty unique in the state. And we have found some information in the city of Memphis case, but they were grasping as well for authority. And they cited Burnell, as we saw in the text, when they went through form, and then they also went through the unconstitutional on its face. I believe I'm remembering what we saw on the screen. And then we have the parenthesis about this rule. And so what Mr. Cooper had argued is that rule of construction that we always use. I mean, it's a rule of grammar that when you use a general term like rule, what does it apply to? Well, you look close to the text near it. And the close text to it was right there. So the rule of grammar, and it's also been used within statutory interpretation, is if you want to know what something means, look to see what it's talking about. And he showed me it's pretty close right there. It's just, I don't know, what, about 10 or 12 words before that.
And that's exactly what we want this court to do, because the words preceding the mentioning of Burnell talk about technical procedural defects and facial unconstitutional defects and not subject matter defects. And then when you see past Burnell, the paren, which says applying and explaining, or explaining and applying, however that is the rule, is a clear indication that it does look above and at only those two issues. That would have been a good opportunity for the Supreme Court, had it wanted to expand City of Memphis to include a third category called subject matter jurisdiction. The fact that it didn't do that may or may not be instructive, but it certainly didn't say that there was. And I would submit that this court may not want to make a new rule. And that's all I ask the court tonight to follow City of Memphis as it's stated.
Sure. Okay.
And that's pretty much all I have. I also thank you for the expedited nature of handling
Certainly.
this. I do think you understand how important it is to the people, and this fight is the people's fight, and they appreciate your efforts as much as I do.
Well, I appreciate the thanks, but it's really the lawyers who moved this along. The lawyers have done an incredible amount of work in a short amount of time, and so it's the lawyers who got us here, and that's how we were able to do it so fast. So excellent job in that respect. If anybody's expedited it, it's been all the attorneys who've worked pretty fast on this case, and we've gotten it done. There is one other matter that I need to address. So, Mr. Roberts, does that complete your closing argument?
It does, Your Honor. Thank you.
Good. Thank you very much. The additional matter is this. The trial of this case has only been on part of the plaintiff's complaint. We've tried the case on the time-critical issues, and in the beginning of the lawsuit, the court had separated out other claims that we can try later. Those are the constitutional issues, and then we also have an Open Meetings Act violation amendment, and there's another amendment. So there's some pending matters that have not been determined yet. when the court had inquired recently about that, because Mr. Roberts expanded the scope of what he wanted to put in the second phase of the case, the response by Metro, and I can't remember the election commission as well, is whoever, however this comes out, parties will want to appeal, and they had said in there they wanted an interlocutory appeal. What I had in mind with respect to the ruling that I issue would be to make it final under Tennessee Civil Procedure Rule 54.02. Now, it could be, Dean Koch had cited earlier the law of unintended consequences, and there may be something that I don't see here that the lawyers do. So should the court not make this a 54.02 ruling and just simply then let it go up interlocutory appeal, have you all apply for that, and then I would rule on the papers on that? Would that be the safer course to go? I'm open on that, but I wanted to tell you that was how I was going to handle it, was to make it a Rule 54.02 ruling. Any thoughts about that, Mr. Roberts? And if you all want to wait, then I can just hold off. If you want to think about it more, I know I'm just asking you this sort of on the fly, and you may want to study it more.
No.
If you need more time, tell me.
My guess is that, yes, we would want some sort of final order that was appealable. I had not thought of the vehicle or mechanism to get on appeal. I'm sort of inclined to think a Rule 5402 order would be the most appropriate. But honestly,
well, let me just say that the only problem with that, I know in the past you can't, from the appellate courts have said just because the parties agree that it's 54.02 doesn't necessarily make it so, and we've had some remands on that, and it's a little bit riskier to do that. I had not thought of the interlocutory angle because that's something that you all would have to apply for. But what I'm going to get this out on November 3rd. I'm going to work hard to finish it up and issue it on that day. And then I can just hold off on whether to make it a 54.02 or you all file an interlocutory appeal and just leave it up to the lawyers. That way you can think it through and determine how you want to proceed. Would that work for you, Mr. Roberts?
Yes, Your Honor.
Okay. And then after I issue the decision, just know that if you want it made final under 54.02 or you wish to seek an interlocutory appeal, file immediately so we can keep it moving fast and stick with our time critical good work we've done here. All right, let me ask the Election Commission. Dean Koch, any preference on that? Anything that you want to add to what the court stated?
Well, Your Honor, my dusty memory is recalling an opinion by Judge Sam Lewis on the Court of Appeals back in the mid-'80s, where he kind of threw a wet blanket on using 5402.
Well, I can blow the dust off that because that's happened to me very frequently and recently. And so your memory is correct, and it's still the case. It's kind of a landmine on appeal. It's a bit risky.
Well, you warmed my heart that I wasn't off base. Thank you.
It's the same. Yeah.
May we perhaps address this in our supplemental brief that we're filing?
Yes, that's a good idea.
And I think it's more of interest to Mr. Roberts and Mr. Cooper than perhaps to us. But I do think
that's a good suggestion. Yeah, let's do that. Let's put it, you all are going to file those briefs on Thursday. And let's address it in there. That would be good because it would be nice if I could actually put that on my order. It would eliminate some work and some additional briefings. So that's an excellent idea. So that works for the Election Commission. Mr. Roberts, will it work for you to put it in your reply brief?
Yes, Your Honor.
Okay. And Metro, what about you all?
No, we have some of the same concerns about 5402 avenues. So yes, we would like the opportunity to address that. We appreciate the court's willingness to tee this up for a quick appeal by whichever party might want to do that.
Good. All right. We'll just address that in your reply brief, and I'll take it from there so we can make it pretty streamlined on an appeal. And we can do a lot on the papers if we need to. Very good. All right, let me check with our court reporter. Is there anything, Ms. Seif, that you need before the court adjourns.
I think I'm good. I've emailed Justin earlier, so yeah, I have his email if I need mine. So thank you.
Thank you. All right, the court will take the matter under advisement, and I will issue my decision on November 3rd. That concludes the trial of this case. And again, I want to thank the lawyers for their quick, excellent work in the case. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
All right, court is adjourned as to this matter.